Hello and welcome. My name is Hermie Abraham, and I'm the owner and employment lawyer at Advocation. Advocation is an employment law firm that helps professionals, as well as small to mid-sized organizations, achieve amazing outcomes when faced with workplace obstacles as well as opportunities. And I am taping the first of my Ask Hermie video series where I answer your burning employment law questions. And the first question comes today from an employer who wishes to remain anonymous, and they have a question with respects to employee disability management. And the question is as follows. The employer has an employee who's been on sick leave, and during the sick leave, the employee sustained an accident, not at work, through no fault of the employer. And now the employee has been on leave for 2 years. Now, the employer has arranged an independent assessment from a specialized medical doctor to determine whether the employee can be returned to work. And the independent medical assessment found that the employee could return to work on a gradual basis and with modifications to the employee's duties. And notwithstanding all of this, the employee still refuses to come to work, and they're claiming that they're permanently disabled and unable to work for the employer. And the employer wants to know whether they're obligated to pay the employee notice and severance. And this is an excellent question, a wonderful way to start Ask Hermie, because I find that disability management is a hot topic for both employers and employees. So this question sheds some light, and hopefully we'll be able to answer the question for many other people. So the first thing that the employer should know, and any employer watching this video, is that under human rights legislation, you have a legal duty to accommodate an employee to the point of undue hardship. And what does that mean? It means that as an employer, you have to seek options and opportunities within your workplace to return the employee to work on a full or modified basis, either in their existing role or another role that might be available within the organization. Now, in this particular fact pattern, it sounds as if the employer has done what they should as far as the legal duty to accommodate, because they went for an independent assessment to find out what the employee could do. They were able to find out the employee could return gradually with modified duties, and they offered presumably this to the employee. Now the employee is still saying that they're not able to work, so what to do now? So I'm going to look at this from two different scenarios, and of course each situation is going to be based on the facts. So I'm going to look at two different scenarios, assuming two different sets of facts. So let's assume first that the employee's refusal to return to work is based on an assessment that the employee has received from their own medical doctor that says that the employee is permanently disabled. And so in this particular situation, the employee's refusal is based on medical information, but one that's contradictory to the assessment that the employer obtained. If the employee is no longer able to work in the employer's workplace, that might be considered frustration of contract. And frustration of contract essentially happens when the contract can't be performed by one party through no fault of either party. So the example I like to give for frustration of contract is if you can imagine a truck driver who loses their eyesight. Now, in that situation, obviously the truck driver can't continue their work as a truck driver, but the fact that they can't continue is no fault of the truck driver, but also no fault of the employer. And when frustration of contract happens, the employer and employer are entitled to treat the contract as permanently ended. And in those circumstances with frustration, the employer is required to provide termination entitlements to the employee in accordance with the Employment Standards Act. Now, I will say with frustration that it's based on the employee's inability to do the work. So it doesn't really matter, as in this situation, that the employee has been off of work or on leave for a particular period of time. Frustration happens when there's the inability to fulfill the work that the employee was doing, and there's no other opportunities for them to be able to return to the workplace under a full or modified basis. So that's scenario number one, a frustration of contract scenario. The second scenario is assuming that the employee has no medical information to substantiate their desire to not return to work. And so the employee isn't going on a medical information, and they're not listening to the assessment of the independent practitioner that was hired by the employer. The employee's refusal is just the employee's own refusal. And in those situations, if the employee is refusing to work, it could be a job abandonment situation. And job abandonment is essentially the same as a resignation. It's the employee signaling to the employer that they no longer wish to work there. And in those situations, the employer is not required to provide any termination entitlement to the employee. So no notice, no severance, and that's both under the Common Law or Employment Standards Act. So those are the two different scenarios, but again, always based on the facts of each case. And I will say to any employer who's looking to either treat a contract as frustrated or treat a employee as abandoning their position, to please seek legal advice before you do. Please speak to an employment lawyer. And I say this not to be self-serving, but simply to recognize the fact that your strategy in taking any type of legal action, not like a lawsuit, but any type of legal steps against an employee, to prevent it is a lot easier than curing it if you've made a mistake. So it's always best to come to the problem with a sound strategy that you know you're fulfilling your legal rights and obligations. So with that, I have answered the question, hopefully. I hope you found this answer helpful. If you did, please share it with people in your professional and personal contacts who might find the video content useful and might answer some questions that they have. And please send your questions to me. I'm looking to answer as many questions as possible and shed light on employment law and workplace law questions that are burning and ones that you can't find the answers easily. Now, you can send your questions to me at askhermie@avocation.ca or through my website, and I will include links below. Thank you very much for listening, and I will see you next week with another question. Take care. Goodbye.